Uma agência independente tenta determinar a causa exata da explosão. A Chemical Safety Board procura saber quantos produtos químicos estavam armazenados no prédio e quais deles foram misturados.
That explosion occurred without warning during the middle of the workday and injured a large number of people, some quite seriously. 16 people were hospitalized, 4 in intensive care, and 15 others were treated and released. Our team arrived shortly after the explosion on April 26th, and it included lead investigator Steve Selk and Don Holmstrom, and my colleague, Dr. Poggi, who was the board member on scene at the time. The team has continued to investigate this incident over the last 12 months, and they're now ready to release the staff's findings.
Madam Chairman, the investigation team is ready this morning to report our preliminary findings to you and to the people of New York City. We have concluded that the explosion directly resulted from the mixing of chemical wastes that were incompatible with each other. The company that produced these wastes, Kalteck Industries Group, did not have adequate procedures in place for handling chemicals. Kalteck did not maintain a list of hazardous materials it had on hand. Employees were not shown material safety data sheets or trained on the hazard information contained in them. And some of the containers of hazardous chemicals found on the premises were not labeled. It appears that management and employees of the firm were not aware of federal safety regulations requiring these things. On the day of the explosion, employees were cleaning up. That morning, several drums of waste had been taken from the basement up to the garage level and removed from the building by the licensed hazardous waste transporter without incident. But down below, an employee in the basement had been complaining for some time that a leaking 15-gallon container was emitting a foul odor. A foreman asked workers to transfer the contents of the leaking container to a drum. Workers then transferred the liquid from the leaking container and also from about a dozen other 15-gallon containers to 55-gallon drums. They used an electric pump to do this. They thought that the liquid in the containers was spent etching solution. A minute or so after they finished, a noise was heard coming from one of the drums. It began as a hissing sound and quickly increased to a roar. Liquid was spraying upwards from one of the drums. Employees started to flee towards the exits from the basement, a center hall stairway, and an auxiliary exit. Before many could escape, the drum exploded. The explosion did not only harm employees working at Kalteck. 14 members of the public were among the 31 injured. These included a delivery person, painting contractors who were working in the upper levels of the stairwell before it collapsed, and even a handicapped student at a technical college in an adjoining building. Beyond injuries, the explosion forced tenants from all 10 floors to evacuate. Madam Chairman, while we cannot be certain of the exact chemicals and reactions involved in this incident, we have information that nitric acid was found at the scene, and evidence indicates that it was mixed with other wastes. A chemical reaction occurred. From our knowledge of chemistry and from the totality of the available evidence, we conclude that nitric acid most likely reacted with lacquer thinner, causing a sudden release of energy and evolution of gas. This caused the 55-gallon drum to explode. The chemicals in question are materials that need to be handled with care and expertise. Our investigation indicates that Kalteck lacked the expertise to safely manage the chemicals it used in its manufacturing operations. The federal government has developed standards for the management of hazards from workplace chemicals. When followed, they can prevent incidents such as this. The chemical regulations are required by the federal government through the Department of Labor's Occupational Safety and Health Administration. However, that agency, OSHA, does not have the resources to proactively inspect all workplaces. particularly those of small business. Kalteck had never been visited by OSHA. I have talked about federal and state regulations, but in many cases, local governments also exercise control over hazardous substances. In the course of our investigation, we have noted that fire codes in other localities outside New York have some features that are more highly focused towards the safe handling of hazardous substances. Specifically, model and other fire codes may, like the regulations mentioned earlier, require that workplaces maintain material safety data sheets, label all containers, and submit hazardous materials management plans before permits are issued. Our objective today is to provide a forum for you and your colleagues and others gathered here to learn more about the workings of this complex arrangement. Among us today are a variety of officials from various agencies and departments, as well as subject matter experts and interested parties. We have invited them to gather with us and asked them to focus on the role that local oversight can serve to prevent incidents such as the one that occurred last April 25th.
As you may know, the mayor in November of 2002 created an advisory commission to advise him on the prospect of updating the city's building code and adopting a model code. The commission recently completed its review of the issues and of two model building codes, the IBC 2000 and the National Fire Protection Association's NFPA 5000. This initial review was focused on the format and ease of adaptability to the provisions of the existing New York City building code. If the Commission's recommendation is to adopt a model code, then the process will be aimed at modifying the model code text to reflect the intent and high standards of the existing New York City code and to take into consideration the unique conditions found in New York City.
The New York City Fire Department's primary mission is to provide fire protection, inspection, and prevention services to the 5 boroughs of the city. To help fulfill this mission, a comprehensive and easily enforced fire prevention code is one of the best tools to achieve life safety, property protection, and continuity of building operations. With regards to the storage and handling of hazardous materials, New York City clearly presents unique safety concerns, owing in part to the city's extreme population density, traffic density, and extensive underground networks. In response to these significant public safety concerns, in what manner does the Fire Department enforce the specific provisions of the existing New York City Fire Prevention Code and rules? To ensure the safety of life and property, specially trained inspectors from Bureau of Fire Prevention visit all premises where hazardous materials are used, offered for sale, and/or stored. Such materials include flammable and combustible liquids, compressed gases, aerosols, acids, motor fuels, and the list goes on. Roughly 200,000 fire safety inspections are conducted annually by the Bureau. The majority of these inspections relate to the use, sale, and/or storage of hazardous materials. The Fire Prevention Code of the City of New York was originally adopted in the year 1918. Since that time, amendments have been adopted on a piecemeal basis. Typically, the primary driving force behind these amendments were incidents and tragedies that identified the need to regulate certain areas or change the manner in which certain areas were regulated. Nonetheless, the Fire Prevention Code of the City of New York has never undergone a comprehensive review or revision.
DEP is an integral part of the city's first response team. DEP houses the Right to Know database, which is now more comprehensive than any point in its history. Over the life of the program, DEP's Right to Know staff, part of the Division of Emergency Response and Technical Assessment, known as DIRTA, have developed a citywide facility inventory database used to track chemical storage throughout the city. To enhance the program, the Right to Know program has selected and inspected specific industries known to be non-compliant or unfamiliar with the reporting requirements of the Right to Know law in order to make the database more complete. DEP is confident in the level of interagency communication and cooperation before and during emergency responses. In fact, we will soon be expanding and developing additional methods for accessing Right to Know information.
During the investigation of the fire, there were several summonses that were issued to Kalteck: illegal storage of paints, no C of F holder for air compressor, no permit for an air compressor, illegal storage of flammables, illegal storage of oxygen, and acetylene tanks.
In retrospect, it appears that there were regulations that covered everything, and in glancing through the report, it looks as though there were people who did some degree of inspections. What are your thoughts about what additional resources or provisions or things might have assisted any one of you in reducing the likelihood of the type of incident that occurred at Kalteck?
Obviously, there's any incident. If we have one incident, it's one too many. And this was a very critical incident. What we try to do, again, is develop as much information with right to know, and we handle that. So that is preventive in nature, and it works in the vast majority of incidents. Obviously, it did not work here.
I think the answer is to get the code up to where it should be, and then to implement an inspection program that, within the constraints that the city has, with budget-wise, to get a program out there where we can get the job done.
Have you looked at it? Is there a way to cross-educate people so that the fire inspector goes in and, he may be looking for fire extinguishers, but if he saw an operation like this, it would trigger something in his mind to report it through another mechanism to other agencies where there may be a concern. In terms of cross enforcement, it gets into a whole lot of issues. How much you have to pay somebody who is a super inspector and doing the entire building. But certainly, having one inspector go in, inspect the entire building for all the fire code violations, anything that affects fire safety, and then having him leave is a very nice thing. It's a nice thing for us. It's very efficient for the building owner. It's been talked about and it's been considered, but it is a big job to implement something of that nature.
Are people knowledgeable about the right to know provisions in the city of New York, and are they availing themselves of that information to be more vigilant for materials being used in their immediate environment?
Unfortunately, I guess more now than ever in the world we live in, it's very difficult to put out information with respect to chemicals to occupants, to the general public, from a security perspective.
So this weighing of rights to know and rights to protect from an evil intent is the crux of a very serious dilemma for social safety and social security that I think needs serious examination before we adopt what happened after 9/11 as being the sole imperative for protecting our communities. There is too much of a history of the management of hazardous materials that has led to the poor outcome of too few people knowing what was being handled and how best to respond, endangering the lives of many other innocent bystanders.
I understand that they were permitted to store 500 gallons of flammables and 1,000 gallons of paint. How does that, from your perspective as professionals in the firefighting business, is that an appropriate amount of flammables to be stored in the basement of a multi-use building? And how does that volume compare with a model fire code amount?
From a fire protection standpoint and a safety standpoint, it's not an appropriate amount for the basement. But it may not have violated any city code, other than the fact that they didn't have a permit from us for that, and perhaps the certificate of occupancy issued by the building department did not indicate that the basement was approved for the use of some type of manufacturing process.
I guess they're thinking about an inspection with regard to hazardous chemicals. They go to the first floor, but they don't go to the basement. Why would that be?
Sometimes it may happen that the inspector doesn't get to floors because he was not aware of or he was not informed that there was any type of manufacturing activity going on in those floors.
If you noticed that there were working conditions that were not being, poor working conditions, no labeling, would you report that then to OSHA? Do you have any authority to pass that on to another agency or to DEP if that's their authority? Could you do that?
Well, in this program that we just enacted, we have notified the field units to let us know if they see any improprieties in regards to storage, permits, housekeeping, anything like that. They would let fire prevention know, and then we would let the other agencies know.
I really want to make this genuinely clear to everyone that the need for us to act appropriately when we have a violation of this magnitude or any magnitude is there. We will act accordingly, and the message will be sent.
Was your department actually ever visit the Kalteck site?
Yes, we did, sir.
Okay, and so for whatever the reason, the unlabeled cans and things just were either hidden or escaped your attention or something?
That is a fairly
Okay.
accurate assessment, sir.
Okay.
Do you have any ideas of how you would reach the multitude of smaller facilities to give them knowledge of what had happened here and what is the existing rules and regulations and standards that the city would want everybody to adhere to?
Awareness is good. Communication is good. We didn't want this incident to happen. You didn't want this incident to happen, but as you said before, we can use this as a way of sending out a message which is clear and concise to people that yes, we are doing our jobs collectively, and we will not tolerate any situation that will compromise the public. We consider you a partner.
Make no mistake about it, the adoption of modern building and fire code will cover many more hazardous materials as currently addressed in New York City's present codes and will require a new way of thinking about hazardous materials. Enforcement will be more difficult as a direct result of the more broad and extensive requirements. However, I believe that New York City will reap substantial benefits in the form of fewer and less devastating hazardous materials incidents.
Our fire code, NFPA 1, the Uniform Fire Code, represents the most comprehensive means within the NFPA codes and standards system by which to address the storage, handling, and use of hazardous materials, whether liquids, gases, or solids. The purpose of NFPA 1 is, quote, to prescribe minimum requirements necessary to establish a reasonable level of fire and life safety and property protection from the hazards created by fire, explosion, and dangerous conditions. The code establishes a sequence of steps that must be followed whenever hazardous materials are going to be stored, handled, or used. The first step involves a classification of the hazard, in the most general terms as either physical hazards or health hazards. And again, that's an extension beyond what we've heard the New York City regulations have traditionally dealt with, where they've limited it to the physical hazards. The code even addresses procedures for dealing with both mixtures and materials having multiple hazards. The code then establishes permit requirements for the storage, dispensing, use, or handling of hazardous materials in excess of a minimum threshold quantity, a quantity above which the permit requirement becomes actionable. Linked very closely to the permit process might be a requirement for a hazardous material management plan, which we've heard about from the two previous speakers, along with appropriate hazardous materials documentation.
Just like NFPA, our code basically says that the employees have to be trained. We don't break it down and say that it has to be in different languages. It just says that every employee needs to be trained to the hazards they're working with. And however that has to be done, we don't basically break it down specifically. It follows the OSHA standards and the Fair Labor Act.
Okay.
And the training issue, we also have the certification for fire inspectors, and just like NFPA, it's not specific to a municipality that adopts our code. Anybody can become certified regardless of what code you're using or if you're using any codes.
There should be uniformity in reporting from point of manufacture and sale to monitoring and placarding during transportation to a chemical's final use and storage on site. There should be reporting at this endpoint to local fire jurisdictions in order to assure storage requirements are complied with and allow us in the fire department to conduct pre-fire planning.
Kalteck Industries, this accident happened for one reason and only one reason: poor government, lack of enforcement. You guys all sat here, you all heard everybody speaking here about all the laws, all the things that you guys wrote. Brilliant pieces of work. Some doctors up there, professors, I understand. Really great things. I'm sure you did a great job. But there's nobody on the street enforcing them. It's that simple. If you don't put people out there to enforce the laws, you're going to have these incidents happen.
The fundamental problem here is enforcement of laws that are on the books, in that no one is opposed to creating new laws to make it safer for the people of the city of New York. The fact is there are a multitude of laws on the books that were not followed in this incident. I was shocked when I heard today that Kalteck had no record of HAZCOM training, no proper labeling of materials, no MSDS sheets available for inspection, yet this is a large waste generator. And if you're a large waste generator, you have to file gobs of paper. This isn't a red flag for someone to walk down and say, hey, we just want to make sure you know what you're doing here.
The Kalteck explosion in Chelsea was not an isolated event. As you know, there are 25,000 toxic fires, spills, or explosions each year, at least 1,000 of which involve deaths, injuries, or evacuations. The density of New York City's population and the mixed-use character of its buildings and neighborhoods makes the widespread use of toxic substances a serious threat to all of us. Kalteck has a largely immigrant workforce. According to OSHA, Kalteck conducted no health and safety training and provided no material safety data sheets. We believe this situation to be typical of many New York City employers. This situation is compounded by lack of government oversight and lack of government enforcement. OSHA is woefully understaffed, meaning that most workplaces, including Kalteck, are rarely or never inspected. Even with stepped-up enforcement, hazard communication standard is still problematic. The standard does not require training on the hazards of accidental combinations of chemicals that are designated non-reactive. A combination of these same non-reactive chemicals caused the explosion at the Kalteck building.
I really appreciate all of your comments. You put a very personal and human face on this event from all of your perspectives. Although there was no one killed in this incident, we deal with incidents on a daily basis where there are people who are killed and become the victims of chemical incidents that are not unlike this one on different scales. Your comments and your approach and your recommendations will be weighed in our recommendations as we proceed, and we thank you very much for your comments. While today's hearing was focused on the ways the city codes can be more effective in preventing chemical accidents, our report will also address some of the broader issues that have also been raised by this event. Small businesses that use hazardous materials are common throughout this country. If those businesses were not following good safety practices or environmental practices, and they are not being effectively inspected, then the public is at risk. Certainly the public was endangered in this case, and the public would have had very little awareness of the danger that they lived so closely to. Kalteck, no doubt, missed many opportunities to learn about the safety and environmental requirements and to implement effective programs. I've said this before, but I'm not sure that there was ever a clearer case of how inexpensive the cost of safety is compared to the cost of this serious accident. Very straightforward safety measures would have saved this business and spared its employees and its neighbors much anguish. Some agencies had adequate rules on the book, but evidently lacked the resources to inspect or enforce. Others may have had the resources but lacked the needed regulatory authority covering hazardous materials. The Kalteck accident challenges us to do better. With that, I thank everyone, the board and the panel members and the members of the public and those of you who sat through this. I hope you learned a lot about what we do, and we look forward to meeting with you again this next summer. With that, this hearing is adjourned. Thank you.